Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discussing some of very important MCQs related to Indian polity. Let's start the first question. In the context of the Indian polity, consider the following principles. First statement, responsible government at the center and the state. Second one, executive being part of legislature. Third one, parliamentary sovereignty. Fourth one, judicial supremacy. So which of the following statements are correct? If you see the first one, responsible government at the center and state. This statement is correct. As we know, Council of Ministers in center are responsible for Lok Sabha and Council of Ministers at state level are responsible for state legislative assembly. So first statement is correct. And the second statement is executive being a part of legislature. This is correct statement. So some of the executive means ministers. Ministers are part of MPs and MLAs. So that's why this statement also correct. And third one, parliamentary sovereignty. And the fourth one, judicial supremacy. Both third and fourth are wrong because in our country, constitution is supremacy. So that's why parliament is not supremacy. So not sovereign also, and judicial supremacy also not there. So in our country, constitution is supremacy. Parliamentary sovereignty is in UK. There it is parliamentary sovereignty. In judicial supremacy is not there in India. So that's why 1 and 2 are correct, 3 and 4 are wrong. If you see the explanation, Article 75, the Prime Minister and the Council of Ministers are collectively responsible to the Lok Sabha. Article 164, at the state level, the Chief Minister and the Council of Ministers are collectively responsible to the Legislative Assembly. So next question, consider the following statements with reference to the Public Accounts Committee. The Public Accounts Committee consists of 22 members, including 15 from Lok Sabha and 7 from Rajya Sabha, and ministers are eligible to the members. Second statement, the term of the office for PAC members is 1 year and the committee is reconstituted annually under rules of procedure and conduct of business of Lok Sabha. Third statement, since 1967, the chairperson of the PAC has been appointed from among the members of the ruling party. So which of the following statements regarding Public Accounts Committee are correct? If you see first statement, this statement is wrong. So up to here it is correct. But here ministers are eligible to be a part of Public Accounts Committee. So this is wrong. Ministers are not eligible to be a part of Public Accounts Committee. And there are total 22 members, 15 from Lok Sabha, 7 from Rajya Sabha. And if you see the second statement, this statement is correct. So the term of the office of our PAC members is 1 year. And if you see the third statement, this statement is wrong because the chairperson of the PAC has been appointed from the opposition party, not from ruling party. That's why this statement is wrong. 1 and 3 are wrong, second is correct. If you see the explanation, 1 and 3 are incorrect as ministers are not eligible to be members of PAC. Since 1967, the chairperson of the PAC is typically appointed from the opposition, not the ruling party. So next question. Consider the following statements with reference to the Finance Commission of India. First statement, the Finance Commission is constitutional body that is reconstituted by the President every 5 years under Article 280 of the Constitution. Second statement, the mandate of the Finance Commission includes making recommendations on the principles to govern grants in aid to states from Consolidated Fund of India. Third statement, the recommendations made by the Finance Commission are binding on the government. So which of the following statements are correct? First statement and second statement are correct. Third statement is wrong because the recommendations made by the Finance Commission are advisory in nature, not binding on the government. So that's why third statement is incorrect. And if you see the first statement, the Finance Commission is constitutional body. So it is mentioned in the Constitution under Article 280. So that's why it is a constitutional body that is reconstituted by the President every 5 years. So this statement is correct. On the recommendations of Council of Ministers, this body is established. And if you see the second one, the mandate of the Finance Commission includes making recommendations on the principles to govern grants in aid to states from the Consolidated Fund of India. So this body gives recommendations how much percentage of money need to be given to each state. So there is a vertical division and horizontal division in Consolidated Fund of India among states and from center to state. So next question, This is the explanation. Statement 3 is incorrect. The recommendations of the Finance Commission are advisory and not binding on the government. If you see the next question, the instrument of instructions contained in the Government of India Act 1935 have been incorporated in the Constitution of India in the year 1950 as fundamental rights, directive principles of state policy, extent of executive power of state, conduct of business of the Government of India. So which of the following is the correct answer? So the instrument of instructions contained in the Government of India Act 1935 is same as directive principles of state policy in our constitution. As we know, our constitution consists lot of articles from 1935 Government of India Act. So that's why in that there is a section called instrument of instructions. So in that also they mentioned what government need to do for the welfare of our country. So that is the same as directive principles of state policy mentioned in our Constitution 4, part 4 of our Constitution. So that's why second statement is the correct. B is the right answer. The British has introduced certain instrument of instructions in the Government of India Act 1935. These instrument of instructions were to be followed by the Viceroy in policy making and betterment of masses. These were later incorporated as DPSPs in the Constitution of India. DPSPs seek to promote social and economic democracy in the country and are non-enforceable in the courts of law. Next question. Consider the following statements. First statement, the Advocate General of a state in India is appointed by the President of India upon the recommendations of the Governor of the concerned state. Second one, as provided in Civil Procedure Code, High Courts have original, appellate and advisory jurisdiction at the state level. So which of the following statements are correct? So as we know how Attorney General for India, there is Advocate General for every state. So this Advocate General of every state is appointed by the Governor, not by the President. So but that's why this statement is wrong. So Advocate General of a state is appointed by the Governor on the recommendations of Council of Ministers of that state. So this statement is wrong. Now second statement, as provided in the Civil Procedure Code, High Courts have original jurisdiction and appellate jurisdiction, not advisory jurisdiction, because advisory jurisdiction is given to Supreme Court, not to High Courts. What is original jurisdiction means? So that means we can go to High Courts directly in some cases like fundamental rights violation and any civil cases that are more value. So in that case, we can directly approach the High Court. That means that is original jurisdiction. What is appellate jurisdiction? That means if a lower court gives any rule, that can be appealed in High Courts. That means it has appellate jurisdiction also. So that's why High Courts has original jurisdiction and appellate jurisdiction, but not advisory jurisdiction. Advisory jurisdiction means President can take advice from Supreme Court regarding anything that he is unable to understand from the Constitution. So Supreme Court has the advisory jurisdiction, but it is not mandatory on the government to follow that one. It is just an advisory. If you see the explanation, the Advocate General of State is appointed by the Governor of the concerned state, not the President of India. According to the Article 165 of the Indian Constitution, the Governor appoints a person who is qualified to be appointed a judge of a High Court to be the Advocate General for the state on the recommendations of the state cabinet ministers. High Courts do have original and appellate jurisdiction at the state level, but they do not have advisory jurisdiction. Advisory jurisdiction is a power granted only to the Supreme Court of India under Article 143 of the Constitution, where the President of India can seek its opinion on matters of public importance. Next question. The problem of international liquidity is related to the non-availability of goods and services, gold and silver, dollars and other hard currencies, and exportable surplus. Actually this question is Indian economic question. So answer to this one is dollars and other hard currencies. So the problem of international liquidity is related to the non-availability of dollars and other hard currencies. If you see the explanation, the problem of international liquidity refers to the shortage of internationally acceptable currencies, mainly hard currencies like the US dollar, euro, etc., that are needed for countries to settle their international transactions. If a country does not have enough of these currencies, it may be struggle to pay for imports or service its foreign debt. This issue is particularly significant in international trade and finance. So next question. Article 156 of the Constitution of India provides that a governor shall hold office for a term of 5 years from the date on which he enters upon his office. Which of the following can be deduced from this? First one, no governor can be removed from office till completion of his term. Second one, no governor can continue in office beyond 5 years. So if you see, this is one part of Article 156, but there are other parts in 156 also. So it said that governor can be removed if president agrees. That means governor can stay until he has presidential approval. After, if president is not willing to continue this governor, he can remove him from office at any time. And no governor can continue in office beyond 5 years. This is also wrong. So he can continue beyond 5 years also. So that's why these two statements are incorrect. If you see the explanation, statement 1, no governor can be removed from the office till completion of his term. This is incorrect because Article 156 of 1 of the Indian Constitution provides that the governor holds office at the pleasure of the president. This means the president can remove the governor at any time, even before completing the 5-year term. No governor can continue in office beyond 5 years. This is also incorrect because Article 156 of 3 states that a governor shall hold office for a term of 5 years, but they can continue in office beyond this period until their successor assumes charge. Therefore, a governor may serve longer than the 5 years if their successor is not appointed immediately. So next question, with reference to the President of India, which one of the following statements is not correct? More than 5 former Vice Presidents of India were later elected as the President. Second statement, oath of the President is administered by the Chief Justice of India. Third one, both the President and Vice President can resign from their office by giving resignation in writing to each other. Fourth one, no candidate has been elected unopposed in the presidential elections till date. So which of the following statements are correct? I mean, here they are asking incorrect statement. If you see the first one, till now there are 6 vice presidents who later become as presidents. So that's why this statement is correct. And if you see the second one, oath of the president is administered by the Chief Justice of India. This is also correct statement. See the third one, president can resign by submitting his resignation to the vice president, and vice president also can resign by submitting his resignation to the president. So that's why this statement also correct. If you see the last statement, no candidate has been elected unopposed in the presidential election till date. So this is incorrect because Neelam Sanjay Reddy been unopposed in presidential election. That's why this statement is incorrect. If you see the explanation, till now 6 vice presidents become presidents after their vice presidential term. Neelam Sanjeev Reddy elected unopposed in presidential election. Next question, who among the following are appointed by the president on the advice of the Council of Ministers? First one, chairman and members of the Finance Commission. Second one, chairman and members of the Election Commission. Third one, Attorney General of India and Solicitor General of India. So which of the following statements are correct? So which of the following members are appointed by the president on the recommendations of Council of Ministers? So if you see first one, chairman and members of the Finance Commission, this statement is correct. They are appointed by president on the recommendation and the advice of the Council of Ministers. And also Attorney General of India and the Solicitor General of India also appointed by president on the recommendations of advice of Council of Ministers. But this statement is wrong. So chairman and members of the election commissioners are appointed by the president on the recommendations of PM and leader of opposition and any member from Council of Ministers. So So the cabinet minister. So that's why this statement is wrong. So 1 and 3 are correct. If you see the explanation, statement 2 is wrong because election commissioner of India is appointed by the president on the recommendation of PM, leader of opposition, and any one cabinet minister. The next question. Which of the following statements is are correct with reference to the ordinance making power of the governor of a state? First one, it is a discretionary power. Second statement, in case of bicameral legislature, ordinance can be promulgated when the state legislative council is not in session. Third one, it is wider than the legislative power of the state legislature. So which of the following statements regarding ordinance powers of governor are correct? If you see the first one, it is a discretionary power of governor of the state. No. So ordinance making power is not discretionary power. It is based on recommendations of the council of ministers in that state. So that's why this statement is wrong. And if you see the second statement, in case of bicameral legislature, ordinance can be promulgated when the state legislative council is not in session. This statement is correct. So ordinance can make even assembly is not in session or legislative council is not in session in case of bicameral legislature. This statement also correct. If you see third one, it is wider than the legislative power of the state legislature. No. So which laws can pass in state legislature can also be promulgated using ordinance power, but it is not wider than the legislative power of the state legislature. So it is a temporary law. So it is not wider than the legislative power of the state legislature. Ordinance making power of president is mentioned in Article 123 and ordinance making power of the governors is mentioned in Article 213. So this is the end of today's class. Thank you very much for watching.